Once you've identified the questions you are interested in answering, it may be 4, maybe 5, depending on the particular exams you are writing. It may be more than that. You'd then start to answer the questions. But don't forget to time yourself when you start your first question. If you decided that you are spending 20 minutes on each question, then time yourself. Check your time so that you'll be able to know when you spend 20 minutes. And that would help you to be a bit more structured with your answer. Once that time is gone, go to the next question. If you've not finished, just leave some space and go to the next question. Because you see, if you do not finish answering, if you are expected to answer 4 questions and you answer 3, the 4th question carries its independent marks. You will never get any score for that question because the lecturers cannot put something on nothing. So you've deprived yourself of a whole question. And no matter how brilliant you are, you will not do as well as you would ordinarily have done if you answered 4. So if you completed your exams. So one of the ways that students fail exams, even when averagely good students, is the fact that they did not finish, they did not complete answering the questions. If it's a different thing if you cannot answer because you didn't know, but because you did not manage your time well. So redeem your time, if I can put it like that. Now, so you start answering. Now, to start answering your questions as a law student, students would usually have known that, okay, there are different ways that they ask your questions. But you must understand that law is about life. Law is about reality. Law is about human behavior, human interactions. And as a lawyer, you are going to be solving problems. Law is about solving the problems of others. Even when you want to say you want to incorporate a company, you are going to solve somebody's problem who wants to go about incorporating their company. Law is about solving problems. When you begin to practice, people will come to you and tell you a story. They tell you a story, they tell you a problem, and they want you to solve it. It's the same when you go to a doctor that you work, a story about health. But law goes beyond, it's wider. That's why they say lawyers are learned. Therefore, what the exam questions do is to replicate those real life situations. They tell you a story or they give you a statement that they want you to attend to. In doing your basic application, therefore, in answering your question, as a law student, you generally have the information that, okay, some questions are problem questions, some are essay questions. I know that there are students that are in levels where they may have to do some CBT exams, maybe year 1, but we are actually today talking strictly about law exams, especially when you are in levels like year 2, year 3, year 4, or year 5. Even those who are in year 1, if they are doing, I think they do legal methods and what have you, the principle is the same. Either they give you a story that you are expected to solve the problem in the storyline, or they write a statement, what you normally call an essay question. Whichever way the question comes, so you have to determine what is the nature of this question. Read the question critically. When you are reading the question, you would notice as you are reading, as you get to these points where they've said some what we call issues, you will know, because what you have read, the content that is within you begin to make connection with that story. And so, oh, this question is about consideration in contracts. Oh, this question is about specific performance. You would see, based on your knowledge, you've read. If someone that is not a lawyer and has not read any law books were to read that question, they will not even know anything that is consideration. It's just a story to them. They might say that there is a problem. Of course, if two people are fighting on the, and you say, what is the problem? You say, oh, this is my tailor, and I've told her to make my clothes, and she has failed to deliver, and I've paid her. So you have to refund my money and return my clothes. So they will know what they are asking for, even as laymen. But when they come to you, you put it in legal language. Put it in legal language. So you read your questions and you know that the content that is within you, the preparation, the knowledge of the law that is within you will help you to pick even the central theme. What is the central theme? What is the central focus of this exam, of this question? So it will be a shame if you are answering a contract exam and you are talking about criminal law. I mean, that would not, that doesn't show that you are adequately prepared for exams. Read the question, you will know the general area of the law that it's talking about. Then you know the specific areas by paying attention to details. We will not go into that today. Next video we'll be talking about, maybe look at some questions as you need to practice. So pay attention to the details and be able to pick out what the question is about. So is it an essay question? If an essay question, what is it saying? What is it asking me to do? What is that question asking me to do? For essay questions, for instance, I would say that your knowledge of English becomes very critical. I'm trying to see if there's just one I can read to you. I'm not going to read the present questions now. A question that says, for instance, knowledge or awareness as a necessary element to be proved by the plaintiff in an action for assault, battery, and false imprisonment. Knowledge or awareness is a necessary element to be proved by the plaintiff in an action for assault, battery, and false imprisonment. Discuss this statement analytically with the aid of decided cases. And a lot of the law exams, they will tell you to do that with a lot of decided cases or with relevant authorities or what have you. So what you do with a statement like that is to look at what the statement is saying. Pieces the statement. Do you even agree with it? Now it says discuss analytically. Is it a correct statement? Does it represent the law or not? Is knowledge or awareness necessary in assault, in battery, in false imprisonment? How would you start answering the question? Okay, of course, for you to discuss the knowledge, you cannot just come to class and to the exam hall and say knowledge is not necessary and you stop. No, you have to engage in a discussion that's as if the examiner does not know it. Write as if the examiner does not know anything about it. Don't assume that maybe he knows the meaning of assault or he knows the meaning of battery. No, you got to write as if you are trying to teach the examiner the law. So read your question, whether it is essay or problem. In problem questions, the essay will sometimes have a statement like this. Sometimes it just says discuss or explain or critique or identify. Listen to the question under the statement. If there is, read the question under the statement and analyze it and ask yourself, break it down into its key components. Then you'll be able to answer adequately. So in the next video, we'll be looking at some of these in terms of practicals. Then if it's a problem question, the same thing goes. What is the central theme of the question? Like I said, is it consideration? Is it remoteness of damage in tort? Is it consideration in contract? Is it parties to an offense in criminal law? There's always a central theme in a question and then the specific area and issues. Just like when they were teaching you in class, the lecturer will come to class and tell you. So they will want to look at consideration in contract, or we want to look at breach of duty of care in negligence, or we want to look at the Land Use Act and customary land tenure. The lecturer will come to class and tell you that is a general area of the law they want to consider. But when they start discussing, then they will tell you, make a statement, then they might say, but in a situation where the breach of duty of care is by a child, this is the principle as an exception to the general rule. So when you see a question that is dealing with this breach of duty of care, and then you see a child, you say, okay, the issue is relating to maybe the standard of care for a child. Then the lecturer continues to teach and says, oh, in a situation where this and this, all those sub statements and points that they make in the course of teaching you breach of duty of care in negligence or consideration in contract or customary land tenure system, those sub, or in this case, the question was not really failure to obtain governor's consent. The question was that the consent was given by a person that is not the governor and has not been delegated by the governor by any instrument. So the issue of governor's consent is the general area, but the specific points that the question wants you to attend to is whether other people apart from the governor can be the ones that will sign, the CFO, or if it's revocation too, whether it is he can delegate it. So you need to pick up those salient points. The way to do it for you as a student is during the time you are preparing. What is the content of your preparation? What is the law? Even when you are having an essay, a problem question, you still need to write an essay within the problem question. You need to tell us what is the law robustly. Most students don't do that. They just think that, okay, it's a problem question. I just tell the person, okay, as if well, if your client is with you in the office, you tell them, well, I think you have a good course of action. I think we should file for this or that. You give them some framework. But in the exam, we want to see even the content of what you are going to say in court. We want to see the law in the action. So I don't assume that the examiner knows every word. Define it. If the way they defined it for you in class, if they talked about overriding public purpose, what does it mean? Don't just say a governor can revoke a land for overriding public interest or for breach of the terms of grant, and then you go on. No, take time to explain. Overriding public purpose is defined by section 51 of the Land Use Act 1978 as meaning this. You take it step by step, and your answer will be rich. So I would say, therefore, that you read your questions very well in detail and don't miss out the issues. Identify how many issues can I see in this question. Why would an examiner give you a question that is the only one issue? That means you have not seen the other issues there, that you're going to answer in 35 minutes, a whole question, and then you write 6 lines and you think you are finished. There's something must be wrong. You have not picked the issues as they ought to have been picked. So do that and you'll be on a safe page. Identify the key issues in the questions. When you have identified the key issues, so every law student knows what we call the phrase identify the issues. And what are issues? Most of the time students say they don't know what is the issue. What is the meaning of issue? Issues mean problem. What is the problem between the parties? What are they contending about? What are they fighting about? If you met I gave the example, if you met two people quarreling and you try to ask them and say, what's the problem? In other words, what's the issue? And she says, oh, I gave her my car. I gave him my car to fix. The car is overheating. And he has said it's going to cost this amount to fix it. He dropped the car. I've paid him. I used the car today, and the car is still overheating. What's the issue between them? Is the issue the fact that he took my car away? No. Is it the fact that he brought the car back? He's brought the car back. I'm not asking him for my car. But the question is that he's collected money for a particular service that he will fix overheating. And as far as I'm concerned, he has not fixed it successfully. So it's either that I'm saying I want my money back, or he's got to fix this car back without me having to pay again. Some people say it's return job. Or I give my clothing to a tailor. I say I want this fixed. Oh, I want skirt and blouse, and I want this particular style. And the person returns the clothes and brings it as a dress. Then I reject it and say, no, I told you to make skirt and blouse. So the problem is not that there's a problem between a tailor. So if you come and say, oh, it's between the tailor and the customer. Yes, that's the general issue. That's relationship between the parties. You have defined their relationship. But what are they fighting about? Fighting about the fact that this is not the style that I told you to make. And the tailor says, no, you told me to make this. And I say, no, I told you I wanted skirt and blouse. And she says, it's so how do we establish it? And you are saying, I'm not going to pay you your balance. And she's saying, no, you have to pay me my balance. So they are fighting over the style of the clothes. Not just that they are just a customer client relationship, no, but the particular problem between the two of them is the style of the clothes. And then she is making a claim, you've got to return my money, and then maybe return the money for the clothes. And the seller says, no, I've completed the contract, I want to be paid my balance. How do you help the two of them? You're not going to talk about history of contracts in that case. You're not going to talk about, you're going to focus on the particular relationship and discuss that relationship in the eye of the law. So you pick the issues, look at your question, pick all the issues out first. Don't just see the first issue and then begin to write. Pick all the issues, the problems, the that you know, the the, the something like the puzzles that you can find in the questions. Put them down, then look at them. How do I structure the answer? Which do I take first? Can I put these two together? Create a structure for your answer before you start answering. That way, it may seem like you are slow because some people have started writing, they are writing 2 pages, and it appears you have not started. But by the time you start writing, I can tell you that the answers will flow effortlessly because you have a structure on ground. You have organized your answers and you know where you are going. You will be able to do more in less time. Then, one of the things I've noticed about students is that, oh, I've read a particular area, I know it very well. They look at a question, they just see 1 or 2 keywords in the fields that they have read, and they begin to answer. They set a different question for themselves. You must answer the particular question that the examiner has set. Many times we don't do that. We don't answer that question. It's as if you set a question, another question for yourself. If you do that, there's a marking scheme. The scheme is looking for particular answers. Focus on that scheme. The examiner is going to focus on that scheme. So is it what I asked you? So you see a student that would have written eloquently. They've written law. But is that the law that is relevant to the issue? So that's why some say, oh, I wrote very well. I wrote 10 pages. I cited all the authorities. But if that is not what the question is asking you, you have not answered the question. Somebody cannot come to your office as a lawyer and is telling you that somebody was killed with a gun. And you go to court and be arguing that this is the knife that was used to kill somebody. What is knife got to do with it? So you've got to focus on what is the examiner asking me. If the marking scheme were to be placed beside my answer, would there be a synergy? Will there be a rhyme? Can we see the same things, the keywords, the cases flowing from within each other? So you've got to make sure that it is you explicitly answer the question that is being asked. Don't set another question for yourselves. Students are fond of doing that. They'll just talk. Maybe sometimes some of them don't know the answer, so they just feel like, let me put some things down in that area. Let them pick the answer. Yeah, you may get a score that you let my people go. But if you are aiming for excellence and you want to be the best, then you've got to look at that question and answer the question that you have been asked. Then you need to support your answers with authorities. You see, in law, it's about authority. It's about following what has been said before. What authorities exist? As a student of law, in your first year, you've been told about sources of law. You don't go to court and be telling the judge your opinion, even if you are the best lawyer in the town. We are talking about where is the authority? Where did you get that information from? You have the primary sources of law, you have the secondary sources of law. What authorities were cited in your class? And in talking about authorities, every area of law has 1 or 2 locus classicals that people will know. You are answering a question in thought on remoteness of damage, and there's nothing about the wagon mond, and you think you can answer the question. If so, any field of law, whether it's contract, you want to talk about breach of contract, you want to talk about implied terms, you want to talk about criminal law, you want to talk about land law, you need to know the authorities that are germane, the locus classicals. That sometimes I tell students, as a lecturer in thought, I'll tell them, even if you go to an exam or I don't know any other thing to write, there are some cases you can just put on your page to show that at least I know that these cases exist in thought. And I say that in a lighter mood, because it just shows you how important those cases are. That it will show that at least you studied thought. Okay? And if you go to an interview and they say, oh, my best subject is thought, even if you don't know any other thing, if you're able to say this case, how would a student of thought not know Donoghue and Stevenson? How you explain Orlando, not talk about Savannah, Bankanajilo? I would give light industries in Chinekwe. No, so some cases are very critical to say that you have a knowledge of a particular subject area. So know your locus classicus. Okay, that is very important. So that's just about generally how to answer law questions. There are specific things that we'll talk about as we approach some of the questions. How long do answers have to be to earn good marks? There is no length. I don't know. It depends. So many things. If you have your right content, then put it down in writing. If you need to ask for extra sheets, there's no prescribed number of words. There are some questions, the area of law, if you are doing legal research and writing, that they may say, right, I'm abstract of 200 words, for instance. So apart from those specific areas and fields of study, what we are interested in is the substance of your answer, not how long how many pages you've written. You can write 2 pages and do better than someone that has written 4 pages. It's the substance, how weighty is your answer. So should one use the elements of a concept to raise issues for them? Raising your issues, it's always a problem for a lot of students. But I would just say generally that in raising your issues, you have to be as specific and near to the issue as possible. Oh, like the examples I've given you, the issue is not whether a mechanic and the client have a quarrel, but what is it? The car is overheating. Raise an issue around that. So you need to get the facts of the case right. Who are the parties? How many parties did they mention there? What did they do to each other? And when you know what they have done to each other, you'll be able to pick the real issue. What did they do to each other? What that thing that they did to each other forms the foundation of an issue. So we'll be raising some issues as times goes on. So let me just leave that. How to raise issues without whether or not, or without sounding generic. Well, I used to say to students that whether or not has been the traditional way of students raising issues. But usually when you are talking in practice, how many people ask questions? Because issues are in raising issues, you are asking questions. You are teasing out questions from the facts before you. Do you talk to people and say whether or not? You don't usually do that. You ask questions in a better way. How or what or whatever. And so raising your issues without whether or not. If you cannot, that's the only way you can raise it in that way. But if you can do without it, then do that. To what extent is somebody liable for battery where he has slapped another person unintentionally? Is it battery to kiss a sleeping person? Is it false imprisonment to lock the door against someone mistakenly? You need to know the facts, get the facts right before you can create an issue around it. Sometimes people will create the same issue, 2-3 issues, and they are speaking about the same thing. So it would, in subsequent videos, be looking at the practicals of this. How to finish on time. The way to finish on time is to allocate time to yourself, like I said earlier. How to apply cases to issues and practical ways of applying IRAC. IRAC that all of you have always said. How to apply cases. Your cases can be applied in different ways. It depends on what the question they are asking you. Some cases can just put the principle and what was held. Some cases you have to discuss it, break it down into pieces because of the way the question is asked. So there is no general way, but it's not ideal to just put in your cases. Just take the case, list 10 cases, and just don't do anything with them. You need to use your cases to do something. Your cases must do something. They must be action. They must be like verbs. They must be doing something within your answer. Okay. So with those general framework, I think that's just a general framework that does not apply. That applies to every course. Use your cases. We can stop this presentation today, and in subsequent videos look at some questions and attempt to create issues or to answer those questions to give you some vibes as to what really happened in practice. Don't forget to like the video, subscribe to the channel, and also share.